chapters 11 and 12 are going to look at the juvenile justice system. Chapter 11 in particular is going to look at the rights that juveniles have and how their cases are processed. So when we talk about the adult criminal justice system, we just refer to that as criminal court. Juveniles have a separate system, and their court jurisdiction depends on how a particular state has defined what constitutes a juvenile. So for the majority of states, this is people who are at least 18 years old, but it is as low as 16 and 17 in some other states. So juvenile delinquency is the violation of a criminal law by a person prior to reaching the age of majority. And again, that age of majority is determined by the state in which the juvenile lives or has actually committed the crime. Juvenile delinquency includes both regular criminal offenses, things that would be illegal for anybody, and what's called status offenses. Those are crimes that would not be crimes if an adult has committed them. They're basically a crime because of their status of being a juvenile. This includes things like running away, truancy, and curfew violations. So one of the things that has happened over time is the juvenile court has really tried to deinstitutionalize status offenders. So in the past, status offenders would be come into the court's jurisdiction and they might be sentenced the same way an actual juvenile offender would be sentenced. And in 1974, the Juvenile Justice and Delinquency Prevention Act wanted to address some issues because they had this concern about growing juvenile delinquency. This act established the OJJDP, and established that status offenders should not be incarcerated in penal institutions. So they might still find themselves in something that's called residential treatment. So another thing that happens is the courts also have jurisdiction over what we call children in need of services or child in need of services. That's a CHINS, and that's the term Massachusetts uses, but other states might use PINS, person in need of supervision, or MINS, minor in need of supervision. These are neglected, unmanageable, abused, or other types of children that are in need of services. Generally, the courts have broad discretionary powers over people under the age of 18. And so this could be kids who are basically refusing to follow their parents' rules. And basically what happens as the juvenile court is developed is it's looked at with this doctrine called PARENS, PATRIAE, and that literally means the state as father. This permits the state to take away the rights of the natural parent and to act in the best interests of the child. This doctrine originates with the King of England in the 12th century, and it still really is a bedrock of the juvenile justice system, which is based on rehabilitation. So modern applications for PARENS PATRIAE allows the courts to have a wide range of discretion in terms of dealing with juveniles. So confinement generally is seen as a last resort. The judge is supposed to act as a parent and make a decision in the best interest of the child. Juvenile courts are technically civil proceedings and they're much more informal. You can't go in and observe juvenile court unless you happen to know the juvenile that is being sentenced at the time. They use different terminology. We don't arrest juveniles, we take them into custody, for example. And not all states allow juveniles the right to a trial by jury. Most juvenile courts are not a court of record, so there's no transcript, and they tend to have fewer punishment options. So juvenile courts are primarily an American creation, and the first one is established in Cook County, Illinois, in Chicago, which is where Chicago is, in 1899. So the juvenile justice system is a little over 100 years old. Other agencies and organizations had been established earlier in other jurisdictions, and they were dealing with juveniles during the latter half of the 1800s. But this process is quickly adopted by many cities. So the first public reformatory for juveniles is the New York House of Refuge. And it's established in New York City in 1825. And it has several goals. They wanted to provide food, clothing, and lodging for all poor, abused, or orphaned youth. The idea here was that these people were looked at as being child savers. It basically was anyone who wanted to assist in helping children and intervening in their lives. Unfortunately, these child savers weren't always necessarily motivated solely by goodwill. Sometimes it was that they sort of felt these were people in power and they felt really bothered by children that were begging on the street. So most juvenile encounters with the police are prompted by a referral from most encounters for juveniles with the system are prompted by a referral by the police. But they can also be made by a school principal, a parent, a teacher, or a neighbor. And usually what we see happen there is that the juvenile is referred through that CHIN system. So what happens is a petition is filed in the interest of the juvenile. So as opposed to charges filed against you, we file a petition in the interest of whoever the juvenile is. This alleges that the juvenile is a delinquent, a status offender, or in need of adult supervision. And it basically is requesting that the court decide whether the allegations are true and determine an appropriate penalty. What happens next is intake, and this varies in formality. It's generally a screening procedure conducted by someone in the court or a probation officer. I worked in a diversion program, and we also did intake screenings where we sat down and we interviewed the juvenile about their prior history and why they thought they were there, and we interviewed the parent as well. Sometimes intake hearings solicit opinions from significant others like police, parents, or neighbors. So generally what happens is one of 5 actions could happen at intake. Well, the person might be dismissed either with or without a verbal or written reprimand. They could be returned to the custody of their parents. They could be returned to the custody of their parents with referrals for counseling. They might be diverted to an alternative dispute resolution program, or they might be referred to the juvenile prosecutor for further action, and this would trigger the rest of the juvenile court system. Juvenile court prosecutors also have a lot of discretion, and they may dismiss cases against certain juveniles or screen them out. One of the things they can also do, though, is refer a juvenile to criminal court. So it's usually done through a prosecutorial waiver, but there are several ways to waive a juvenile into adult court. So the rights that juveniles have are a little bit limited. They don't have the same amount of rights as adults, although they have most of them at this point. And in the mid-60s, we start to see juveniles gain a lot of these rights through a series of court decisions. They don't encompass all the rights extended to adults, but they have had far-reaching implications, and thus has made the juvenile justice process a little bit more formal. So in 1966, we have Kent v. U.S., and Kent has his case waived to adult court, and this is done without a hearing, which his attorney had requested. So the Supreme Court held that Kent's right to due process and effective assistance of counsel was violated. So now if we're going to waive somebody to adult court, we have to have a waiver hearing. We can't just throw them into adult court. There has to be a hearing to determine the appropriateness of that. In 1967, in Gault is one of the most significant juvenile rights cases, and this gave juveniles several rights. First of all, a right to be notified of the charges against them, right to an attorney, the right to confront and cross-examine witnesses, and the right against self-incrimination. If you think about it, all of those are some pretty important rights. If you didn't have those rights, how can you really defend yourself? 1970, In Winship is a little less complex than Gault, but it established an important precedent relating to the standard of proof. So prior to this, the standard of proof in a juvenile court was much lower, and this established the same standard of proof we have in adult court, which is beyond a reasonable doubt. 1971, in McKeever v. Pennsylvania, the Supreme Court held that juveniles do not have a right to a jury trial. So there is no federal right to a jury trial, but many states do allow that, and Massachusetts does allow juveniles a right to a jury trial. So states cannot limit the federal right you're given, but they can certainly give you more rights. 1975, in Breed v. Jones, they looked at double jeopardy. Basically, a juvenile had been adjudicated as a delinquent and then waived to adult court. That's considered double jeopardy. So you need to either file in juvenile court or file in adult court, but you can't try somebody twice for the same offense. 1984, in Schall v. Martin, the Supreme Court issued juveniles a minor setback. The court said that you can hold someone preventatively in detention. Basically, the judge has to see the youth as posing a danger to the community or that there's a risk if they're released. So with adults, generally, we're just looking at, does the adult pose a danger to the community? With juveniles, we're also looking at whether or not there's a risk to the juvenile if they're released. And that wraps up Chapter 11.